બપોરે આવું બપોર બોલાવી લઈશ જેલમાંથી બોલાવીએ કોણ બધા આવી ગયા બાકી રહે મારી રિપોર્ટ નહીં આવી ગઈ સિરિયલ નંબર 29 પેલા સેશન્સ લેવા છે હું કઈ નથી કેતો હું શું કામ કહું હું બેઠો જ છું આખો દિવસ આજે થોડોક મોડો આવ્યો પણ અહીંયા જ છું યસ પુરાવો પતી જાય પછી આવજો એવું લાગે પુરાવો પતે પછી બોલાય
already 17.5 and she was already married in minority. Minority no marriage. उसमें ना जैसे बाइक से 12 क्लाइंट्स आ रहे बॉडी में हॉस्पिटल आ गए बस मैं आई स्टार्टेड विथ बोथ थिंग्स कि अभी से ना पेरेंट्स ना ऑलरेडी मैरिड है माइनॉरिटी का इन हस्बैंड ना जैसी बॉडी में मारा हुआ है मैं बस 64 more clear
we are not going in marriage
what was the view of the what happened section 29 is very clear मेरा पापा ने भूल से हम तो भूल गए थे क्यों मान एक लाइन ऊपर सर आओ पहला भी भूल गए थे सर but was defined sir if honorable court is not understanding section 30 of the POSCO Act because people say that आरोप is clear with divorce दिए sir in that case sir I will not get justice sir मैं relevant para of the judgment sir honorable court has not agreed sir I have a dead point not my different order I will not get proper justice of the court that is right yes sir 164 no sir statement is very possible for my it is very clear so on the same day I estimated that to be
no, that would not make any difference. You had stated to anyone or not. But if court says there might be, we don't know what has happened in the court.
But because victim woman start career, sir, I told she is already married. She admitted that in the cross, but what is the interest? That she admitted to Lagana photograph, any compulsory.
But that would be see. That was not the stage when this debate should have been taken place in the courtroom.
Who started telling me like that? Scolded in front of all the clients and everyone. Otherwise, I am the last person to file any petition on that point. Because scolded always makes it like.
And if the court says there is presumption under section 29, then what is wrong in that?
What about
Then-
section 30?
If court is knowing section 29, court would be knowing section 30 also.
But he was not telling on that.
No, but it was a stage of cross-examining as per.
Arguments.
It was-
Argument was starting.
So,
पहले view सर direct है पहले disposition में.
but that would be, we can't say that court has started something.
Open court है. Open court में सर कह रही थी. एक line पर. Otherwise, city arguments are पहला ले लीजिए. तो whatever court use कर दिया. So I started. जो type भी.
PP હતા ત્યારે?
PP साहब बता पा रहे हैं yes on that point of time. અને પ્રાઇવેટ લોયર બી હતા મેં મારા પિટિશનમાં લખ્યું છે એમનો લોયર ઉપર એનો આર્ગ્યુમેન્ટ કરવા જો અપડેટ કે ના સર પિટિશનને બોલાવો પહેલા લેટ હિમ સ્ટાર્ટ ધી આર્ગ્યુમેન્ટ તો કેન આઈ યુ સ્ટાર્ટ એના પછી પીપી સર ઓલસો ધેટ પીપી કે ધેટ કેન બી ઓલસો વેરીફાઈડ ઓન પીપી ઓલસો ઇટ વોઝ ઓલરેડી ઇન ધી કોર્ટ બુક ધીસ ઓલ
લાવ કયું જજમેન્ટ?
સર મેં જજમેન્ટ રિલેવન્ટ પેરા બાદ અને
So your ground is that court has said it section 29.
already the court was fixed with section 29. And 30 it was already added on the press register. But the very long that 15 पूरी भी है. Starting नहीं करेंगे. But मारा भी start करेंगे.
You will get a chance to argue.
But I don't think so. Because he has opened his mind.
No, no. You will get your chance. Make your case from the evidence.
I have already argued that part, but the court was very much fixed. Before hearing the PP, the court was fixed. No, I believe only section 29. Yeah, I wanted permission. That's all. Open court must have carried it. So I can't get this. Okay, I cannot get that. Means really that is to be considered by the courts.
Anyway, કોણ છે respondent? Respondent માં કોણ છે? DN. Yes. તમે ફરિયાદી તરફે છો?
Into the application. Take the application as the honorable. नामदार कोर्ट ત્યારે આર્ગ્યુમેન્ટ કોઈ પણ પક્ષકાર આપના થાવ નામદાર કોર્ટ ને એ પાવર છે કે કોઈ પણ સવાલ ઉપસ્થિત થતો હોય તો પૂછી શકે વોટ અબાઉટ ધ એક્ટ કાયદો શેના માટે બન્યો છે આ કાયદો જે છે એ માઇનોર માટે બન્યો છે માઇનોર ના પ્રોટેક્શન માટે બન્યો છે કેવા સવાલો નામદાર કોર્ટે નોટ અ ફિક્સ કે ભાઈ મારા માઇન્ડમાં આ છે આઈ એમ ઓલરેડી પ્રેઝન્ટ હિયર હું હાજર હતો અને આ વાત સામેથી નામદાર કોર્ટે કીધી છે એમણે સેક્શન 30 માટે કીધું તો સેક્શન 30 રિપીટ એ કરતા હતા નામદાર કોર્ટે ઉપર સેક્શન 29 પણ જોવું પડે.
એક મિનિટ, તમારો રિપ્લાય આવી ગયો છે?
ના સર એટલા ની ઓર્ડર છે.
તમારી એપ્લિકેશન તો છે?
હા સર પણ હવે તૈયાર થયું કે
આજે રજૂ કરી દો. કોપી એમને પણ આપી દો.
No, I don't think so. There is a action.
સાક્ષી નથી આવ્યા જોઈએ આપણે
રાજકીય કુશવા અલાહાબાદ
ખાલી ટ્રાન્સફર એપ્લિકેશન નંબર તો શું આપણે ટ્રેડમાર્ક વાળા એમાં મૂકી દઈશું યસ યસ
this is an application by Prince Sharma. Accused number 25, and he against him the second.
You are Prasanam.
Prasanam Namboodir. Prasanam Namboodir, I am appealing for accused number 25. My lord, he has been made an accused in the second supplementary charge.
You are coming from Maharashtra.
I am coming from Mumbai.
Mumbai. Yes.
He has been charged with section 120 as can be seen from Anna 1 of the application. He has been charged with section 120B of the Indian Penal Code, section 8C, 21C, 23C, 29, and 22C of the UMP. The earlier sections are of NDPS and one section 22C of UAP. I would first argue on the point of UAPA, whether UAPA
Applies or
not. On that point, my first arguments I would like to advance. Why not they look at section 22C of the UAPA.
Yes, 22C.
22C, my lord, it treats as punishment for offences by companies, societies, or trusts. That is the title of the section. And the actual section reads, were any offence under the act has been committed by a company or a society or a trust, as the case may be, every person into bracket, including promoter of company or trust or settler of the trust, bracket close, who at the time of the offence was either in charge or responsible for the conduct of the business, shall be punishable with imprisonment for a term which shall not be less than 7 years, but which may extend to imprisonment for life, and shall also be liable with fine which shall not be less than 5 crore rupees, and which may extend to 10 crore rupees. My lord, this is a provision which has been invoked against him. The case of NIA, if my lord would recall it, it is of import by Magent India, a proprietary concern. This needs to be noted, my lords, that it's a proprietary concern of which I am the proprietor. The applicant is a proprietor. The proprietary concern is neither a company nor a society or a trust. And the only section, my lords would observe that only section of UAPA which is invoked against me is 22C. And I am not the proprietor. I am not the person in charge of a company, trust, or a society. I am the proprietor of a proprietary concern. So my first argument is, my lord, that UAPA provision does not apply at all, because what has been invoked against me is 22C, and 22C.
You are for Magent.
I am for
the applicant Prince Sharma, who is the proprietor of Made in India.
Yes.
My lord would look at page number 332 of the bail application. On the same point, my lord,
Page.
page 332, 332, running page.
Yes.
My lord would observe that it's a part of the second supplementary charge sheet which is filed against the applicant before this honorable court. And the accused applicant is arraigned as accused number 25.
Yes.
My lord would see at the bottom of this page, under acts and sections, where it is mentioned section 120B of IPC, 8C, 21C, 23C and 29 of NDPS Act, and section 22C of the UAPA. And the same thing is again repeated in the last supplementary charge sheet, which is at page number 479. The relevant page is at page 479.
Yes.
My lords would see at in the second table on 479, serial number 2, Prince Sharma, the same sections are repeated with UAPA 22C. So that is the only section which is invoked against me in the charge sheet. This is my submission, and that section apparently doesn't apply to me. So, my lord, then what remains is only the 120B of IPC and the sections which are invoked of the NDPS Act. This is the first submission, my lords. So I would, my endeavor would be to convince my lords that there is no case made out against me under the NDPS Act, and that I was not in any manner involved in any sort of conspiracy for which I can be punished under section 120B of the Indian Penal Code. This would be my endeavor before my lords. My lords, this accused was arrested on 25th August 2022.
25th.
Last year, 2022, 2022.
Yes.
And the case against the accused, as can be seen from the charge sheet itself, which is at page number 387. If my lord would permit me to read, it would be, it would possibly enlighten this honorable court as to what are the charges against me. There on page number 387, my lord would observe serial number 17.10 at the bottom. Role and activities of Prince Sharma, accused number 25. My lord, I would be reading only 2 paragraphs from this charge sheet. So I would only request my lord to be to give me that liberty.
Yes, yes, okay, please.
So this 17.10, my lord, it reads: accused Prince Sharma, accused number 25, is a trusted associate and employee of co-accused Harpreet Singh Talwar since 2019. He used to collect and deliver the cash on behalf of co-accused Kabir Talwar to Hawala operators in New Delhi to evade the suspicion of tax authorities. Investigation has established that on directions of Kabir Talwar, A25 is the applicant before this honorable court, who provided his identity related documents to Sunil Jain, accountant of Kabir Talwar, to open the firm in his name in lieu of funds to be provided by Kabir Talwar as commission on the basis of import consignments. This is my role, my lord. That I had provided documents to accused number 24, that is Kabir Talwar for forming a company by the name Made in India.
Yes.
Accordingly, a new firm in the name of Prince Sharma, that is Messrs. Made in India, was registered on 28/9/2020, having principal place of business at his residential address. Prince Sharma allowed the control of Made in India in the hands of co-accused and employer Kabir Talwar. My lords, this needs to be noted, my lords, that as per the case of prosecution itself, the control of this company was entirely with accused number 24, that is Kabir Talwar.
This was not your argument. in
This
earlier
was not.
application.
This was not my argument. But as far as this application is concerned, my lords would appreciate. I need to compartmentalize my arguments
Yes, yes, yes.
as per the need of the time and the requirement of the accused to form a defense. Investigation has established that Kabir Talwar, and I am very happy to note that my lords has got a very sharp memory, that my lords could recollect my arguments during the last, that was about 2 months back, in spite of that being the case. My lords, I would continue with this paragraph. Investigation has established that Kabir Talwar, in conspiracy with Prince Sharma, provided the name and GSTN of Made in India to Vitesh Koshar, alias Raju Dubai, for further sharing the same with co-accused Sushanta Sarkar, which resulted in delivery of heroin-laden consignment of semi-processed tile stone in Delhi in the name of Messrs. Made in India in the month of November 2020. This heroin-laden consignment was imported by Jesus Christ Impex from Afghanistan through sea route. Investigation has also established that Messrs. Made in India, firm owned by Prince Sharma, never made any remittance to Jesus Christ Impex for purchasing the same semi-processed tile stone. Now, my lord, although this is an imputation against me that the consignment which was imported by Jesus Christ Impex was given to Made in India, but the entire documentary evidence which is placed before this honorable court in the form of the main charge sheet as well as the multiple supplementary charge sheets, nowhere there is any document that the invoice, the copy of that invoice is produced to show that, in fact, Jesus Christ Impex had supplied this material to Made in India. There is no documentary evidence. I would elaborate more on this point, my lords, when I'm taking up that point for argument, my lords. Now, my lords, it continues. Investigation has established that in the month of December 2020, after meeting with Raju Dubai, Kabir Talwar provided the details of Made in India, including IEC for importing heroin disguised as semi-processed tile stone, and Prince Sharma agreed for the same in lieu of funds. Investigation has established that after some time, when consignment of heroin-laden semi-processed tile reached at Mundra port, Amit Sharma, henchman of Vitesh Koshar, alias Raju Dubai, visited Kabir Talwar's office at Patel Nagar, and he told him that for clearing of the consignment, some original signed documents are required. Kabir Talwar, my lords would note here, Kabir Talwar directed Sunil Jain to provide all necessary documents to Amit Sharma. On directions of Kabir Talwar, Prince Sharma has signed all the relevant documents in presence of Kabir and provided the same to Amit Sharma for further necessary clearing of consignment at Mundra Port, Gujarat. My lords, even if this is admitted, my lords, then also what comes out from this allegation against me in the charge sheet is that the documents were signed at behest of Kabir Talwar, who is accused number 24. And it is also an admitted fact that I am an employee of accused number 24. I am a driver of accused number 24, which is also an agreed fact by the prosecution. Then, my lords, during investigation, it has been established that Made in India firm owned by Prince Sharma never made any remittance for importing the semi-processed tile stone. During investigation, it has been established that Messrs. Made in India firm owned by Prince Sharma and controlled by co-accused and his employer Kabir Talwar received a consignment of perfumes from, my lords would observe that the words his employer Kabir Talwar is used here, received a consignment of perfumes from Dubai, which was supplied by Vitesh Koshar, alias Raju Dubai, without any remittance. During investigation, it has been established that he assisted Kabir Talwar in selling the consignments of perfumes in Delhi. That is not an offense, my lords. The perfume consignment was imported and the role of the present accused, the applicant, is that he assisted Kabir Talwar in selling the perfumes in Delhi. Perfumes is not a prohibited or a banned object which cannot be imported into India. The part of the money earned on the sale perfumes were kept by Prince Sharma. Again, my lords would observe that I would be taking my lords through the various statements which are referring to the applicant and prescribing or proscribing a role to him. My lords would observe, and I'm sure that I will be able to convince my lords that nowhere it is stated that any amount was retained by Prince Sharma, that or any amount was paid to Prince Sharma. My lords, then next I would read, my lords, is para number 17.33 in the same charge sheet, which is at page number 411.
Page
411.
Yes.
My lord, it is at the bottom of the page.
Yes.
17.33 offences committed by accused Prince Sharma. Therefore, as per averments made here and above, in the pre-paragraphs, it is established that accused Prince Sharma, as part of the conspiracy, allowed the sale of heroin-laden consignment of semi-processed tile stone by Jesus Christ Impacts to his firm Major India in the month of November 2020 without any remittance to supplier. He is a part of criminal conspiracy, agreed to allow use of his firm, Messrs. Major India, for import of heroin-laden semi-processed talc, thereby facilitating the smuggling of narcotic drugs, heroin, from Afghanistan to India in December 2020 without any remittance to supplier in Afghanistan. He willingly signed all documents relating to imports, custom clearance of semi-processed talc stone at Mundra Port, Gujarat, thereby facilitating transportation of narcotic drug heroin from Mundra Port to Delhi. The accused criminally conspired with other co-accused for raising funds from legitimate import and sale of heroin, knowing that such funds shall be used for commission of an terrorist act by the proscribed terrorist organization, Lashkar-e-Taiba, and thereby accused committed offences under section 120B, 8C, and again, what is invoked against me is only 22C of UAPA.
Yes.
My lords, as far as this is the role which is attributed to me in the charge sheet. My lord would look at page number 554.
Yes.
Before that, my lords, I would like to refer to certain statements which are recorded against me. But there is a possible reference to the role played by the present accused. My lords, there were two bunch of documents which were submitted last time indicating the statements of protected witnesses. I just requested the court officer.
Yes.
My lords may look at the list of protected witness where PW 55 is mentioned at the top. My lords, these are the documents, statements of certain protected witnesses. Although the procedure which is prescribed under section 44 of the UAPA, my case is that UAPA doesn't apply to me, but these protected witnesses statements are being used against all the accused. And the procedure which is prescribed under section 44 of the UAPA, I don't have the access to the court records to establish whether the prosecution has followed that procedure, but I will not press on that point because my case is that none of these statements, whether they are protected witnesses or otherwise, are applicable to me. That is my case. So I would not, but at the same time, I would only draw attention to the fact that the procedure prescribed under section 44 of the UAPA has not been followed. In spite of that being the case, these witnesses have been declared as protected witness without sanction of this honorable court. That is my submission, my lords. But I would not press on that point, my lords. I would first request this honorable court to look at the first protected witness, who is named as X3.
Wanted section 44.
44 subsection 2 would be important, my lords. My lords, it's a detailed procedure where what are the protection available, how the evidence which is forthcoming from the protected witness needs to be dealt with, so that the identity of the witness is not revealed. So my submission is, my lord would observe at subsection 2, a court, if on an application made by witness in any proceeding before it by the public prosecutor in relation to such witness or on its own motion. My lords, neither of the things have happened in this case. But as I said, my lords, it is only an academic argument which I am advancing. I am not pressing this point.
This section, if it is read, it would apply at the stage when the witness is before the court.
Yes, lords, my lords, I appreciate the I appreciate the observation.
When NIA has recorded a statement as protected witness, they would ought to have got the permission of the court. This is your submission.
No, my submission is not that, my lord. My submission is that when those statements are being relied upon in any proceeding, the word uses any proceeding. The proceeding can be a bail proceeding, it can be a remand proceeding, or it can be a trial before this honorable court. If those documents are being relied upon by NIA in any proceeding, then the procedure which is prescribed in subsection 2 and subsection 3 needs to be followed. Only then the relevant portion can be hidden or did not be revealed to me. That is my submission, my lords. I would not, as I said, my lords, my case is that UAPA doesn't apply to me. So that is the reason I am not pressing on this point. My lords would appreciate that the word uses any proceeding. In any proceeding. That is the term which is used. My lord, first I would refer to the statement of the protected witness X3.
Yes.
X3 is at the first page of this compilation. My lords would look at the third paragraph on the first page.
Yes.
It talks about Harpreet Singh Talwar, alias Kabir Talwar, alias Mickey have business of import of goods. It talks about the business of Harpreet Singh Talwar. The second paragraph, the next paragraph also talks about the business of Harpreet Singh Talwar. Same is the case with third paragraph. And the only reference which can be seen is from the third page, my lord. Third page, the second last paragraph. Yes. There is a reference to me. In the month of September 2020, Kabir visited Dubai and met with Sri Raju Dubai, and after coming back, he directed me to create a firm in the name of Prince Sharma. Accordingly, September 2020, Messrs. Majin India was created in the name of Prince Sharma, employee of Kabir Talwar. The firm was in full control of Harpreet Singh Talwar. In November 2020, Kabir Talwar directed me to do a payment of 2.5 lakh. So it can be seen from this paragraph that the protected witness says that it was as per the direction of the A24 that this firm was created, and it was completely in control of A24, implying that A25 was merely a signatory. I would be again arguing on that point, that what is the treatment which the prosecuting agency has given to other signatories. As my lords would recollect, that there are 6 consignments which were imported in this case. And there were other similarly placed IEC holders. Like I am a owner of a importing firm. There are other owners of importing firm who are also similarly placed. I would be discussing on that later, my lords.
They are not accused.
They have not been made accused. They have been given the benefit of doubt, which is unfortunately not extended to me, my lords.
That was also your last.
Yes, that was one of my arguments. Because both the owner of the firm as well as the handler of the firm, both of them have been given benefit of doubts in other 2 cases.
In your case, it is not. Case.
No, VK Enterprises and YM Fashion, in both the cases, the owner as well as handler. I am the owner and accused number 24 is a handler. Both of them have been in other cases not arrested. That is my case, my lords. And it can be seen, my lord, that in the rest of the statement, there is no reference at all to the present applicant. This is as far as the statement X3 is concerned. Now, my lord would go to the next statement, that is at page number 56, 1/8, which is immediately after the this is a statement of X2. In this, my lord would observe that the first paragraph on the next page talks about Sunny and Rahul Vadera. Then also talks about some money transfers. The next paragraph talks about Vitesh Koshar alias Raju from India. Then on the subsequent paragraphs, he talks about the business of Vitesh Koshar and that some payments were made on behalf of Vitesh Koshar to one person, Sandeep and Mohit. Then about Ajay and Deepak Agrawal. I am at page number 4/8, my lords, now. My lords would observe that this entire statement doesn't have any reference of Prince Sharma. There is a reference of Kabir Talwar on 56/7/8, the first paragraph of 56/7/8.
Yes.
On asking, I further state that I heard the name of Kabir Talwar from Vitesh Koshar alias Raju. That is only reference to A24, but otherwise there is no reference to the present applicant at all in this statement. Now, my lord may move to the statement of protected witness M. This also talks about Vitesh Koshar alias Raju, but there is no reference to either A24 or A25.
Yes.
Now the next statement, my lords, is of protected witness SJ. This is a person who is referring to some terrorist organization, where again there is no reference to either A24 or A25. So also PW 117 and 1/2. If my lords have got PW 117 and 1/2. This is also talking about some Kashmir related activities, but not to A24 or A25. Yes. Now my lords would look at the last statement in that compilation of X1. In this statement, on the second page, in the third paragraph, first incomplete paragraph and
Yes.
second complete paragraph and third complete paragraph, it reads as, today I am asked about the role played by me in the import of a consignment of semi-processed tile stones that had arrived at Mundra port in December 2020 in the name of Made in India. My lords, this statement I need to read in its entirety because this is directly concerning the import of the consignment by Made in India. With the liberty of this honorable court, I would read. I say that the said consignment was referred to me from customs clearance at Mundra port by one person named Ritesh Koshar alias Raju Dubai, who runs a company named Vital Nutritions LLC at Dubai, dealing in dry dates, cigarettes, beverages, pepper drinks, etc., which is in the name and of his wife and also registered as at Arshia Free Trade Zone at Khurja near Bulandshahr, UP. On being asked, I say that I was introduced to Raju Dubai by Vijay Sharma, who is my friend and business associate since year 2010. Then he is referring to this person Vijay Sharma and the dealings with Vijay Sharma and the dealings of Raju Dubai in the next paragraph. And on page number 3, internal page number 3, in the middle paragraph, it reads as, later on Raju Dubai assigned me the work of selling his consignment of dry dates lying in possession of one Kabir Talwar, a resident of East Patel Nagar, Delhi, having mobile number so and so and Dubai number so and so. Raju Dubai told me that he owed some money to Kabir Talwar and that the consignment of dry dates sent by Raju Dubai to Kabir Talwar was to be sold and the sale proceeds thereof was to be given to Kabir Talwar for repaying the money owned by Raju Dubai to Kabir Talwar. Accordingly, I met Kabir Talwar at his residence in East Patel Nagar sometime in the end of October 2020, first week of November 2020. There, Kabir Talwar handed me a sample of dry dates, which then I took around various traders of dry dates, dry fruits in Khari Bauli area in Delhi and obtained orders from them, against which I placed orders with Kabir Talwar and dry dates were sold and the payments received in cash were handed over to Kabir Talwar as per the instructions of Raju Dubai. For the purpose of placing orders, I was communicating with one person named Prince Sharma. There is a reference to the present applicant, an employee of Kabir Talwar, but only for the purpose of placing orders and for sale of the consignment of dry dates. From October to July 2020 to 2021, I used to go to Kabir Talwar at least twice a day and met him a number of times for dry dates business. Most of the times I used to see dash at his office located at East Patel Nagar near Siddharth Hotel.
By reading this statement, what do you want to point?
I want to establish this is a person, person X1. He was the person who was involved in clearance of this consignment, collecting the documents from Delhi office of Kabir Talwar, filing the bill of entry, clearing the consignment and taking this consignment to the Delhi godown. He was the person who was completely instrumental and working as per directions of the absconding accused Raju Dubai. In this entire statement, he doesn't impute any role to the present applicant. It can also be seen that this statement only talks about collection of documents from A24. Documents of A25 from A24, accused number 24, Kabir Talwar. It doesn't state anywhere that either A24 or A25 was aware as to what was that consignment all about. And it also clearly indicates, my lords, from this statement that it was this protected witness, so-called protected witness, who was instrumental, who was the agent of this wanted accused Raju Dubai, who was instrumental in doing everything in relation to the consignment of Made in India.
Yes.
My lords would also observe that there were some amounts which were received for the purpose of payment of customs duty and for other expenses. All those are directly received by him from this protected witness from the wanted accused Raju Dubai. There is no amount which has been given either by A24 or A25. I would only read one sentence from this statement. One more sentence. Just one more sentence, my lord. My lord would look at internal page number 5. It says, after clearance of the consignment, Raju Dubai told me that the consignment was to be transported to Delhi and shared with me the name and mobile number of one person named Prem Bhai as a transporter. So he was also involved in the transportation. And then in the next paragraph, he is referring to that some sample of tile stone was given at the office of the accused number 24, Kabir Talwar. And this is what is coming out from the statement of the protected witness. There is no role which can be seen to have been played by the present applicant in the matter of import of this Made in India consignment, except to sign the documents for the purpose of forming the company and handing over the KYC documents for the purpose of filing of bill of entry. Other than that, there is no role which even by the prosecution story is attributable to me for invoking the provisions of NDPS Act or for keeping me behind bars.
Yes.
My lord would also observe that there is another bunch of statements. Of that, all statements are not relevant. The first statement is of one witness by name M, son of N. An application for recording statement of witness, namely M, son of N.
Well, this whole statement is what is your
In this there is no reference to me, my lord. There is no reference at all to me. Then in the second statement, which is statement of SJ, son of SK. This is again concerning the Jammu and Kashmir and JKLF and all those organizations. There is no reference to A24 or A25. Then my lords would go to 115(1)(8) after that statement. It is not serially numbered, so I would not be able to say the page number. It is of X1.
Yes.
X1 is relevant. In this statement, on D1156/8. Before that, D1155/8, there is a reference to I'm sorry, my lord. D1154/8 would be relevant to understand the sequence. 1154/8.
Yes.
My lords can see from the 7th line from top. There is the date 10th December 2020.
Yes.
10 दिसंबर 2020 को फिर वितेश कौशल राजू दुबे का कॉल आया और उसने कहा कि मुंद्रा पोर्ट में पर मेरा कॉस्मेटिक का कंटेनर आया है, उसके लिए क्लियर करने के लिए CHA ढूंढो और कबीर तलवार से कंपनी के पेपर ले लो. मैंने कबीर के ऑफिस मेजन इंडिया नाम के कंपनी के पेपर लिए और मुंद्रा पोर्ट गया। इससे पहले मैं कांडला एयरपोर्ट पर शिपिंग लाइन वाले का ऑफिस में पेपर दिया। शिपिंग लाइन वाले ने मुझे कुछ पेपर दिए और लेकर CHA ऑफिस मुंद्रा सिटी में पेपर दे दिए। वितेश ने मुझे 1-2 दिन से कहा कि तीन दिन बाद कि मेरे लिए ट्रांसपोर्टर का नाम अरेंज करो, क्योंकि then the top portion of on the next page is not readable. आदमी नहीं जा रहा था। मेरे लिए इस नंबर से मैंने इस नंबर से वितेश का नंबर करके, जिसका नाम ठाकुर और वितेश के कहने पर मैंने ठाकुर को अराउंड 15,000 एडवांस दिया। ही इज रेफरिंग टू ए ट्रांसपोर्टर माय लॉर्ड। और अगले दिन दिल्ली वापस आ गया। 3-4 दिन मुझे ट्रांसपोर्टर का कॉल आया जिसने कहा कि पैसे नहीं आए, मैं इसलिए ट्रक गुड़गांव रुका है। और मैंने ये बात वितेश को बताया, पर उससे बात नहीं हुई। My lord, they are referring to the transportation of the consignment after its clearance at Mundra port. 2 दिन बाद मैं वितेश से कहा के कहने पर पेपर लेते इग्नू कॉलेज साकेत गए, जहां एक आदमी स्काई ब्लू जीन्स और व्हाइट शर्ट पहने थी। वह आया और मुझे गोडाउन की तरफ ले गया, जहां पर ट्रक खड़ा था और क्रेन बड़ा व्हाइट बैग अनलोड हो रहा था।
Yes. From this statement also you want to
Say that there is no role attributed to me.
you.
Yes, my lord. And this is again the same person who was involved in clearance of the goods.
Clearance.
He was involved in collection of documents as well as clearance of the goods. So if there is any role which can be said to be not above board, which has been played by me, he would have definitely revealed that. Am I, my lord, we will break for the lunch. And my lords, I would only request my lords to permit me to read 2 more statements from this bunch. And after that, I would be again referring to that VK Enterprises and Vyom Fashion. And then on a recent Gujarat High Court judgment in one of the co-accused matter, where the IC holder has been enlarged on bail.
Lady accused.
Lady accused. And then there are some case laws which I will explain.
Yes, how much time are you going to take?
I will take half an hour more, my lords.
Half an hour more,
Yeah.
because there are 2 FS in 2 cases. FS is to be recorded.
Okay.
It will take.
I will try to wind up quickly, my lord. I will not exceed half an
Or
hour.
I may take first the.
Yeah, you
FS.
can take first.
If otherwise, if you are going to conclude within half an hour, Tamare, why half an hour? It is.
So we can start at 4 o'clock. By the time my lords can complete the FS.
Okay, so we would complete the FS.
Yes. Accused number 24. I would also rely on the reply which was filed by the prosecution in this matter. I would rely on the page number 10 of the reply.
Yes.
My lord would observe that para 35. At para 35, the role of the present applicant is enumerated. And it can be seen from Roman 5, Roman 6, Roman 7, that the role was limited to opening on the firm and providing the documents and nothing more. Except for point number 7, where it is saying, it is said that there is a commission also received, but there is no evidence which has been adduced with the charge sheet to this extent. Also in Roman 9, my lord, at the bottom of the page, it is mentioned that the consignment which was imported by Jesus Christ Impex, it was sent in the name of Made in India. But there are also no evidence except for this bare submission. There is no evidence which has been reduced to charge sheet. At the stage of bail application, what needs to be considered by this honorable court is what is the evidence which is available, which if proved during the course of trial would result in a conviction or not. If there is no evidence, then there is no question of any proving of those evidence. That is my humble submission. It can also be seen from Roman 11, my lords. Roman 11, the last sentence, starting from A24. It says A24 directed his accountant to provide all necessary documents to the prosecution witness X1, that is the protected witness X1, not prosecution witness, and all signed documents by A25 of A34, that is the present applicant of Made in India, were provided to the PW X1, that is the protected witness X1. So it is an admission by the prosecution itself that the documents were provided at behest of A24 by A25, as per the directions of A24 to A25. Similarly, in Roman 12, it is mentioned that in lieu of importing heroin-laden consignment of semi-processed talc in firm owned by A24's employee A25 and other such firms owned by A24, A24 had received 15 consignments. Again, the imputation is towards A24 that whatever consignments were imported in the name of Made in India, A34, was entirely received by A24 and not A25. I would emphasize that A24 is Harpreet Singh Talwar and A25 is the present applicant before this honorable court. And in the next page, role and activities of Prince Sharma. Again, the same thing is repeated more or less, my lords. I would not trouble my lord by taking through all these things, but it is the same thing which is repeated, that the entire activity has been carried out only to the extent of providing documents, nothing more. There is no imputation in the entire reply, my lord, that A25 was possessing any conscious, possessing any idea as to the contents of the consignment which was going to be imported by Made in India, and hence it could not be said that there was any knowledge which can be attributed to A25. My lords would turn to page number 15. Page number 15 of the reply. I would refer to C, the small c in that, in brackets, single bracket. It is submitted that during initial stage of investigation, protected witness X1 was called for interrogation based on evidence surfaced at that time, and his statement came to be recorded on 30th September 2021 by DRI under section 67. And the protected witness had specifically stated and revealed the role attributed to Kabir Talwar in the import of semi-processed talc stones through Made in India, which is nothing but providing documents. Whereas it was the protected witness X1 himself who had actually carried out the entire process of import, including filing of bill of entry, payment of customs duty, payment of to the CHA and other parties involved in the import, arranging of transport, taking the goods till Delhi Godown and unloading it at Delhi Godown. Everything was carried out by the protected witness X1. Now, my lords, I would finally on this point that my role was limited to opening of a company at behest of my employer A24, and that the documents were provided at the behest of my employer to the protected witness. I would submit that beyond that, there is nothing which is available either in this reply or in the form of any document in the main charge sheet or in the subsequent 3 charge sheets. So I would draw a parallel with as I had argued earlier, VK Enterprises and VM Fashion, which is also seen from the charge sheet. My lords, I would now go back to the charge sheet, the third charge sheet, para 17.5.3, which is at page number which is at page number 372, my lords. My lord, I would only read the relevant portion because in any which ways it is concerning VM Fashion, and the next paragraph is 17.5.4 is concerning VK Enterprises. It can be seen, my lord,
380,
page number 372, my lord.
Yes.
Page number 372, 17.5.3. The heading states Messrs. VM Fashion Surat. Investigation has established. This is part of the second supplementary charge sheet which has been filed by the prosecution against me as well as A24. Investigation has established that Messrs. VM Fashion is a proprietary firm of Anil Rajkishore Paikre. As is the case in the case of the applicant, the present applicant, who is a proprietary, is a proprietor of the proprietorship firm Mejan India. In this case, Anil Rajkishore Paikre was a proprietor, registered at shop number so and so, bearing IC number so and so, who imported semi-processed style stone as mudra through bill of entry number so and so. In January 2021, Sri Rajat Kumar Harcharan Singh Gangwani, alias Goldbai alias Lovely Bai, approached Sri Anil Rajkishore Paikre and taken his IC on commission of 8 to 10% for import of Jamdani sari from Bangladesh with the help of Sri Vetesh Koshar alias Rajubai of Dubai, who he knows for 6 to 7 years. In March 2021, Vetesh Koshar Rajubai informed Goldbai that he can earn approximately 2 lakhs if he gives his one firm for import of one consignment of semi-processed style stones. Now, Your Lordship, this person, this Anil Rajkishore Paikre, his statement was recorded during investigation. Statement of Rajat Kumar Harcharan Gangwani was also recorded. Both these statements are part of the charge sheet.
Yes.
But neither of these persons have been placed under arrest. In that case also, in the case of VM Fashion, the role was for providing documents for the purpose of import of a semi-tile stone consignment. And it is the allegation of the prosecution that even in that case, the consignment contained heroin, a narcotic drug. Same is the case with 17.5.4, my lord. If I am going very fast, my lord may indicate. 17.5.4, which is on the next page, VK Enterprises. The proprietor's name is Vicky Kukureja. And the consignment was, the only difference is the consignment was, instead of semi-tile stone, it was bituminous coal, in which the consignment of heroin was smuggled into India, as per the prosecution case. And there also the documents were given to one Ajay Sandhu, and finally those documents were used by this Raju Dubai for the purpose of importing bituminous coal, which contained, as per the prosecution story, heroin. My lord, before I conclude on this topic, my lord, I would finally refer to the Honorable Gujarat High Court order, which Your Honor had also indicated in the first section. It is on the page number 569, my lord. 569 of the, my lord, it is in the bail application itself, my lord. It is in the bail application, my lord. Bail application last, not the compilation, my lord. Bail application on the last few pages, page number 569.
Yes.
my lord would recollect that both the husband and wife were arrested of this company called Astha Enterprises. The company Astha Enterprises proprietor was the wife, and the husband was controlling the company. And in that case, my lord would see the observation of the division bench of this Honorable High Court at page number 573 at para 6, my lord. May I read para 6, my lord? Though the investigation has found substantial evidence against husband of the present appellant, who was managing the firm and was also in contact with co-accused during the course of transaction. However, there is no evidence insofar as the appellant is concerned about the appellant being directly in contact with other co-accused persons, including the Afghan nationals, who are both arrested and wanted. No doubt the documents for importing tile powder stones were prepared in the name of Ashi Trading Company. It is not Astha Enterprises. I apologize for that. It is Ashi Trading Company, the proprietorship concern. Proprietorship of the appellant. Appellant is the wife. But it is the case of the investigation itself that such import was through and through managed by the husband of the appellant, and therefore the court has reasons to believe that the appellant, being housewife of a co-accused, had only passively participated and has merely signed on dotted line and answers when called for. The only difference is, in this case, the import was carried out by the protected witness X1, and the present applicant had signed on the dotted lines as per the instructions of his employer instead of the husband. That is the only difference in the present case and the case before the Honorable Gujarat High Court. Then my lord would go to para 9. Yes. Para 8 talks that there is a separate order where the husband's bail has been rejected. And para 9 says the court has taken into consideration the fact that appellant has 2 minor children who are at mercy of the relatives. That is the mitigating factors which have been considered by the Honorable Gujarat High Court. There is no mitigating factor which I have put forth in the bail application. So we can skip para 9. And in para 11, finally, para 11 to 13, after discussing the facts of the case, the present para 11 speaks that the present appellant has been arraigned in the present offence because the firm, namely Ashi Trading Company, a proprietary concern, was registered in the name of the present appellant, and an import-export license was also in the name of present appellant, which is also the case before this honorable court. The investigating agency has recorded the statement of one Machivaram Sudhakar, who is co-accused in the present case and also happens to be husband of the present appellant. During the course of investigation, he in his statement has stated that since his earlier business venture, which was established with his own credentials, was not successful, he started doing business in the name of his wife with her credentials, that is the present appellant. In the present case also, it is a prosecution's allegation that accused number 24, Kabir Talwar, had opened a company in the name of his driver, accused number 25, who is the applicant before this honorable court. He further states that though the said firm is registered as a proprietary concern with his wife credentials, he runs the firm and takes care of his day-to-day operation. That is also the allegation of the prosecution, that the entire affairs of Major India was done by accused number 24. His wife, that is the present appellant, is in no way involved in any of the company's activities. Even the GST returns of Mrs. Ashi Trading was filed by the husband of the present appellant. To that extent, there is no investigation which is carried out by the prosecuting agency. Hence, this question remains unanswered. This statement, along with other material collected by the investigating agency during the course of investigation, indicates that the present appellant was never involved in the day-to-day operations of the firm in question. There is no imputation, my lord. My lord would appreciate that there is no imputation in the entire charge sheet that I, being proprietor of Major India, was involved in the day-to-day operations. On the contrary, the allegation or the prosecution is that it was entirely being handled by accused number 24. And as far as the present consignment is concerned, it is admitted by the protected witness X1 that he had collected the documents, he had filed the bill of entry, and all the subsequent activities concerning the import he had carried out, transported the goods, deposited in the warehouse at Delhi. My submission is, my lord, that this judgment is squarely applicable to my applicant, to this applicant before this honorable court. And in terms of this judgment, I should be granted bail on such terms and conditions as this honorable court feels appropriate. My lord, before I conclude, I would also like to remind this honorable court of the earlier arguments. I don't want to burden this court again by repeating the same thing on the point that there were 3 consignments which are important. The first consignment was by Jesus Christ Impacts, second consignment was by Made in India, and third was YM Fashion. All the 3 consignments had gone to that Nepsarai godown, and it was stored there. And it is a case of prosecution that the imports had happened in the month of November 2020, December 2020, and March 2021. And after that, maybe within a 15 days period or maybe a month, all the consignments traveled to the Nepsarai godown. It was stored there. And after 6 months, that is in September 2021, the officers visited this godown, did the floor sweeping, and sent the floor sweeping for testing, which out of these 7 packets which were sent for testing, 5 tested positive and 2 tested negative. That is the case of the prosecution. So I had submitted last time that if the remnants are found, logically the remnants should be belonging to the last consignment which was stored there, which is of YM Fashion. So that recovery which is made from that godown, it could not be related either to the consignment of Jesus Christ Impacts nor Made in India. I had given an example of a flour mill where flour is put into the mill for grinding. 1 dabba is put, then and the flour comes out. Then the second dabba of the flour, the grain is put, the flour comes out, and then the third dabba. So ideally, what remains in the grinding stone in the flour mill would be the remnant of the last dabba. It could not be of the first or second dabba. This was my humble submission. I just wanted to refresh memory of this honorable court to that extent. But on that point, there is something which my lord asked me whether there are anything new. There is something more I want to add. There, I would draw attention of this honorable court to the compilation which I have filed. Before I go to the compilation, my lord, I would just briefly invite attention of this honorable court to the memorandum of search and seizure at Nepsarai godown, which is at page number 549 of the compilation of the bail application, my lord. And the chemical examination report is also there. I would only briefly ask this honorable court to run through it to establish only one point. The point that 7 places were marked in the godown, which can be seen from page number 549. 549 on the back side, page number 550. My lord would observe from the second last paragraph from bottom. This is the memorandum of search and seizure drawn at the Nepsarai godown, as can be seen from the first page. The godown address is shown as plot number 14, Khasra number 416, Nepsarai, Dhankar Road, New Delhi. And on the second page, at page number 550, in the second last paragraph, it is mentioned. Thereafter, the lock of godown was opened by Sri Balraj Singh. Thereafter, the NIA team, chemical expert and independent witness entered into the said godown, and it was found that the godown was empty. The approximate area of the godown is approximately 50 feet into 58 feet. Remnants in the form of white color powder have been found at some of the spots. These remnants have been seized from 7 places marked as A, B, C, D, E, F, and G, and with assistance of the chemical CFSL expert in transparent polythene evidence bag and sealed with the seal of NIA seal, having impression of NIA so and so, seal number so and so, having national emblem. In presence of the above said independent witness, the godown owner, the seized packets were marked as A1, B1, C1, D1, E1, F1, and G1. During the proceedings, photographs have also been taken by the photographer. Now, my lord, this Panchalama, this memorandum of search and seizure says that 7 packets were recovered during the course of these proceedings. And the subsequent document, which is at page number 551, is the chemical analysis report of these 7 packets. It can be seen from page number 553, para 8. The result of examination is mentioned. And before that, in para 6, the packets have been described. The packets can be seen, my lord, is 0.892 kilos, 1.774 kilos, 0.26 kilos, that is 260 grams, 912 grams, 912 grams, 188 grams, 714 grams, and 1 kilo 68 grams. Total about 7 kilos or something was the total weight of the packets. And in para 8, result of examination, on the top portion of the page number 553, the result of examination is given. A1 and B1 are tested negative for the presence of narcotic drugs, whereas C1, D1, E1, F1, and G1 are testing positive for heroin and other narcotic drugs. Now, my lord, NDPS Act, it evolved in 1985. It was enacted in 1985, and thereafter, Narcotics Control Bureau, which is apex body had come out with a standing order. Standing order which gave instructions as regards search, seizure, storage, drawing of samples, testing of samples, how the remnants have to be received back, how the muddemal has to be stored, how it has to be destroyed under 52A. The procedure is prescribed under section 52A. And in that regard, there was a classic judgment of the Honorable Supreme Court in Mohanlal, which is a part of the compilation which I produced before this Honorable Court. It is Union of India versus Mohanlal and another. This judgment is of 2016. I am sure my lord would be well aware of it. And in 2016 judgment, it very clearly laid down that any sampling process has to be necessarily before the magistrate. At the time of seizure, there could not be any sample. And the reason was because NDPS is a very stringent law. The possibility of misuse, my lord would appreciate that section 42, section 50, and section 53, the mandatory provisions on NDPS, which are the touchstones of NDPS. The reason why these mandatory conditions are there in NDPS is to ensure that there is no misuse. Because of the stringent nature of the provisions, because of the bar of section 37, which doesn't allow the Honorable Court to grant bail without satisfying the twin conditions. Because of that, the mandatory conditions are imposed. And Supreme Court has, in addition to section 42, 50 and 53, also made it mandatory that every sample which is going to CFSL, that sample needs to be necessarily drawn before the magistrate, before the Honorable Magistrate. As a seizing officer, I cannot at the time of seizing draw the samples and send it for analysis. And if it is sent for analysis, then the consequence would be, if without following the procedure under Mohanlal judgment is kept at page number 129 to 158. I would not burden this Honorable Court. But based on that Mohanlal judgment, there have been recent 2 judgments by Honorable Supreme Court. One in Simranjit Singh versus State of Punjab, which is again at serial number 14, that is page number 159, and 162. These 2 judgments are there, Simranjit Singh and Motilal. When I said what are the consequences of not following the mandate of Mohanlal, is in spite of conviction, when everything else is proved against the accused and the accused person is convicted, the Honorable Supreme Court lets off the accused only on the ground that the procedure prescribed for drawing of samples in Mohanlal is not followed. My lord would look at page number 159. There in para 9, the paragraph 15 to 17 of Mohanlal is reproduced. And in para 10, my lord, hence the act, the Honorable Supreme Court holds, hence the act of PW7 of drawing samples from all packets at the time of seizure is not in conformity with the law laid down by this court in case of Mohanlal. The reason is, my lord would appreciate the argument which could come here to counter my argument would be that there was no drawal of sample, the entire packet was sent, but even that is not allowed. Because the mandate of Honorable Supreme Court was whatever is going to the FSL for analysis should be in the presence of the magistrate to confirm the authenticity that it is in fact what has been seized and not anything else. And same is the case with Motilal, which is on page number 162. Where para 13 to 17 is relevant. Para 15, my lord would look at para 15. It is at page number 167. Admittedly, PW2 drew 2 samples from each of the packets of the contraband found in the hotel room and kept them in 2 separate plastic covers. These covers were sealed and the remaining contraband was also sealed, as the prosecution claims that samples were prepared even before packets were sent to station house officer. The submission of the learned senior counsel appearing for the appellant in criminal appeal was that a grave suspicion is created about the prosecution's case, as this action by PW2 was contrary to section 52A of NDPS Act. My lord would observe 52A. 52A very clearly says after seizure, the goods needs to be deposited with the station house in charge. And thereafter the samples have to be drawn. In my case, in the case of seizure from Nefsarai Godown, the goods were after seizure directly sent to the FSL, the entire quantity. In fact, the standing order 1 of 1993, which have been interpreted by Mohanlal, in Mohanlal by the Honorable Supreme Court, very clearly says what would be the quantity of sample which needs to be drawn. In the present case, it is only 5 grams which is required to be drawn. Whereas what was sent to chemical analysis was 600 grams, 800 grams, 1 kilo. And after this controversy, after this, the instructions by the Honorable Supreme Court in Mohanlal and the subsequent judgments, the government has come out with a notification where the rules, which is at page number 171 of that rules is there. In that rule, it is very clearly mentioned, which is that rule is a combination of 1 of 1993 standing order by an NCB and the Mohanlal judgment. That rules also says that the sampling process has to be carried out in the presence of the magistrate and the samples have to be drawn before the magistrate. And it very clearly says that only 5 grams needs to be drawn. If it is hashish, it is 25 grams. And if it is ganja, it is 25 grams. If it is heroin, it is only 5 grams, which is to be drawn. So my submission is, my lord, that
As far as you are concerned, it is not the case of the NIA that any material was recovered.
no, it is not.
So this argument, how
My lord, the reason is that the reply of NIA says that I am hit by the bar of 37. And how would I come out of the bar of 37? Only if I prove that whatever recovery has been made, one, the recovery is not from me, neither from me nor related to me. Second is that the recovery itself is vexatious. In this case, my lord, the allegation against me is that in my consignment of imported by Major India or imported by Jesus Christ Impies and then sold to me, there was a recovery of 7 kilos odd from Nefsarai Godown. Hence, there is a case of commercial quantity. If there is no commercial quantity, then even otherwise the bar of section 37 will not apply. So I need to overcome the hurdle of section 37. That is the reason why both my arguments. First argument is that the recovery which is made from Nefsarai Godown, it is not of the first or second consignment, it is of the third consignment. Second is that even if there is a recovery, that recovery itself is vexatious because of the violation of Mohanlal and the rules, my lord.
anything more?
My lord, I would also repeat my argument that the consignment which was imported by Major India was completely examined, 100% examination was carried out by customs, for which there are statements to the effect. And hence, it cannot be a case, even otherwise, that there could be some quantity of heroin which was come through in that consignment. That is my submission. I pray before this honorable court to grant me bail. I will abide by all conditions as is required. And also there is no scope of me absconding, because when NIA called me in the last week of August, I walked into the office of NIA. If I had any intent to abscond, it is not the case that I was absconding and that I was apprehended for somewhere else. I walked in voluntarily into the office of NIA and I was arrested. That's my humble submission.
Yes, for you also no repetition of the earlier facts.
Sir, no repetition on aspect of facts. Sir, section 43D part and section 37 of LDPS apply થાય છે એ માટે આપશે સર. હું સેક્શન સાથે ક્લિયર કર આપણે ફૂલ મેન્શન કરી દેવાનું હતું. સેક્શન 43D પર ક્લોઝ 5 એવું કહે છે, notwithstanding anything contained in the code, no person accused of an offense punishable under chapter 4. Section 20C is covered under section chapter 4. That's why the bar 43D 5 is applied to the applicant. Notwithstanding anything contained in the code, no person accused of an offense punishable under chapter 4 and 6 of this act shall, if in custody, be released on bail or on his bond, unless public prosecutor has been given an opportunity of being heard on the application of such release, provided that such accused person shall not be released on a bail or on his bond if the court on perusal of the case diary before charging case diary or on a report made under section 173 of the code is of opinion that there are a reasonable ground for believing that the accusation against that person is prima facie true. Your Honor, burden on prosecution on listen, a prima facie case, not in a detail sir बताऊं. Sir, જે factual aspect पर ना argument sir आप साइड में ना सामने. सर दूसरा सर 37 पर हम आप साइड में यानी सारे मार्जिन आप साइड में ध्यान बताऊं. Section 37 of NDPS. 37 apply થાય છે આપણે માની લીધું છે ને એક છે it is on record. Section 37 of NDPS offense to be cognizable and non-payable. 1. Notwithstanding anything contained in the code of criminal procedure code 97C. A. Every offense punishable under this act shall be cognizable. B. No person accused of an offense punishable for offenses under section 19 or section 24 or section 27A and also offense involving the commercial quantity shall be released on a bail or on his bond unless આ condition એમને લાગે છે એટલા માટે કે સર commercial quantity case છે. The public prosecutor has been given an opportunity to oppose the bail application for such release, and second, where the public prosecutor opposes the application, the court is satisfied that there are reasonable grounds for believing that he is not guilty of such offense and that he is not likely to commit any offense while on a bail. The other condition 43D subclause 5 तथा 37 of NDPS Act. આ burden appellant accused પર છે એ burden prosecution પર નથી કે આ prima facie બતાવવાનું છે as per the section sir. હવે સર in a detail અમે જે આર્ગ્યુમેન્ટ કરે છે એ ડિટેલ માં એ અત્યારે ડિટેલ માં પણ જવાનું છે મેટર ઓફ ટ્રાયલ છે. prima facie case मतलब मैं पैराग्राफ मारा रिटन रिप्लाई में बताया थे चार्जशीट ना पैराग्राफ 173 ऑफ सीआर एना मैं पैराग्राफ 36 पैराग्राफ में बताया है कि prima facie आ एक्ट નો રોલ છે સર. ફેક્ટ ઓન રેકોર્ડ છે, ફેક્ટ એડમિટેડ છે કે એમની કંપની ઓનર ઓફ કંપની કોણ છે? એપ્લિકાન્ટ. એપ્લિકાન્ટ ને ડોક્યુમેન્ટ સાઇન કરી આપ્યા છે, ઇટ ઇઝ એન એડમિટેડ ફેક્ટ. આ મેજન્ટ इंडिया कंपनी थ्रू कंसाइनमेंट આવ્યું છે, ઇટ ઇઝ એન એડમિટેડ ફેક્ટ. જે નેપ સરાયમાં આવ્યું છે એ નેપ સરાયના રૂમની ફ્લોર પર વાળા બાદ સર જે નાર્કોટિક ડ્રગ્સ હેરોઇન મળી આવ્યું છે, ઇટ ઇઝ એન ઓન રેકોર્ડ કેસ ઓફ ધી ફેક્ટ છે. તો સર
કેટલું મળ્યું હતું?
એક ગ્રામમાં જ છે સર. સેમ્પલ ઇનપુટ મળી આવ્યું છે 25 ગ્રામ એવું છે. ટોટલ 7 નાખ્યું
એપ્સરાઈમાંથી
અને સર
એટલું બધું સાફ કરતા કેમ મળી આવ્યું?
સર એટલા માટે કે ઇન્વેસ્ટિગેશન દરમિયાન જેમ જેમ ડેવલપમેન્ટ ખબર પડી સર, પહેલા તો સૌથી પહેલા બેચ કન્સર્વેશન કર્યું, સૌથી પહેલા આજે આવી
ફ્લોર
ત્યારબાદ ખબર પડી સર.
તમારો કેસ એવો છે ને કે ફ્લોર ઉપર પડ્યું હતું,
સર હા
બાકી તો ગોડાઉન ખાલી હતું,
સર સાચી વાત છે.
અને પછી વાળીને તમે લીધું એમાં 7 કિલો નીકળ્યું.
હા સર. સર એવું છે કે આ તમામ કન્સાઇનમેન્ટ છે ને એનો અને પ્રીવિયસ 2020 જૂનમાં આવેલું એ તમામ કન્સાઇનમેન્ટ એક મોડેલ ઓપરેન્ડી મુજબ દિલ્હીમાં લેબ સરાઈમાં થયેલા છે, અને એટલા માટે લેબ સરાઈની અંદર તપાસ કરવામાં આવે.
સરાઈમાં ગયા પણ છતાં બી આ એક્યુઝ બધા એટલા મૂર્ખ થોડા હોય કે 7 કિલો હેરોઈન એવી રીતે પડી રહેવા દે.
સર એટલે કહું છું સર,
અને પાછું મળે બી ખરું, અને મળે એવી રીતે કે ફ્લોર ઉપર એમનું પડેલું હતું.
જી સર.
જે નરી આંખે દેખાય એવું નહીં.
જી સર.
તો 7 કિલો જેટલી ક્વોન્ટિટી દેખાય નહીં કેમ માનવું?
સર હોલ ક્વોન્ટિટી કાઉન્ટ થઈ છે 7 કિલોની અંદર, હોલ ક્વોન્ટિટી એને તો તમામ વસ્તુ આવી ગઈ.
ટોટલ કેટલું મળ્યું તો?
એક ટોટલ સર આ હોલ ક્વોન્ટિટી કાઉન્ટ થાય છે. આપણે એ જ કહી રહ્યો છું કે હિરોઈન જ્યારે ટેસ્ટ તપાસ થયો ત્યારે હિરોઈનની માત્રા મળી આવી. સર આપ સર એફએસએલ નો રિપોર્ટ જોશો તો અમે એવું જ કહે છે.
એટલે ટેસ્ટેડ પોઝિટિવ એટલે તમે કહો?
હા ટેસ્ટેડ પોઝિટિવ પર હિરોઈનની માત્રા મળી આવી, હિરોઈનના સબસ્ટન્સ મળી આવ્યા છે. હિરોઈન
સબસ્ટન્સ 7 કિલો હતા હિરોઈનના.
સર એટલે જ મેં કીધું 7 કિલો ટોટલ હિરોઈનની વાત નથી કરતો, કન્ટેન્ટ હોલ કન્ટેન્ટની વાત કરું. એની સાથે ઘણું બધું છે એની સાથે.
ફ્લોર ઉપર તો માટી એ પડેલી હોય.
સર બધું એટલા માટે હું આપણે કહી રહ્યો છું, એટલે તો હીરાસિંહનું જજમેન્ટ છે એવું કે એટ અ હોલ કાઉન્ટ કરવાનું સુપ્રીમ કોર્ટ એમાં સર એટલા માટે સર
હા એઝ એ હોલ કાઉન્ટ કરવાનું ત્યારે કે જરી કોમ્પોનન્ટ્સ એક હોય અથવા તો મિક્સ કરીને યુઝ કરતા હોય ત્યારે હોય કે એકનું કોમ્બિનેશન બીજા કોમ્બિનેશનમાં મિક્સ કર્યું ત્યારે. પણ માટીએ ભેગી લ્યો તમે એવું તો ન જ હોય.
ફ્લોર પર માટી અને હિરોઈન સીધું પાડવું શક્ય જ નથી સર. એટલે હોલ કન્ટેન્ટ જ કરવાનું પૂરતું.
એવું હોલ કન્ટેન્ટ ન હોય.
સર હોલ કન્ટેન્ટ
હોલ કન્ટેન્ટ ન હોય, આપણે જોઈએ જજમેન્ટ. હોલ કન્ટેન્ટ ક્યારે ગણવાનું હોય કે હું સપોઝ કે હિરોઈન છે કે બ્રાઉન સુગર છે કોઈ મિનિમમ ક્વોન્ટિટી લઉં છું અને હું એક સોલ્યુશન યુઝ કરું છું જેને હું બીજામાં યુઝ કરીને યુઝ કરવા માટે લઉં છું. એટલે ઇન્ટેક માટે તમે યુઝ કરો ત્યારે તમે એક ક્વોન્ટિટી લઈ લો બરાબર છે. કોઈ સોલ્યુશન તમે પ્રિપેર કર્યું 1 ગ્રામનું, એને તમે બીજાની અંદર નાખ્યું, એઝ એ હોલ કન્ઝ્યુમ કરી શકાય. તો તમે જસ્ટિફાઈડ કે ભાઈ ભલે તમે 2 ટીપા નાખ્યા છે ને તમે 10 ટીપા બનાવ્યા તો 10 ટીપા ગણવાના રહે. અહીંયા તો ગોડાઉન માંથી રિકવર તમે કર્યું છે, માટીની સાથે કોઈ લેવાનું જ નથી. એવા સંજોગોમાં એ જજમેન્ટ તમારા કેસને એપ્લિકેબલ ન થાય. અને ન્યુટ્રલ એ જે કે છે ન્યુટ્રલ સબસ્ટન્સ એવો સબસ્ટન્સ કે જેની અંદર નાખીને તમે એને કન્ઝ્યુમ કરી માટે લઈ શકો, માટી ન કરી શકાય. તમે જ્યારે આપણે અહીંયા દેશી ડોડા તમે લ્યો છો તો ડોડા લ્યો ત્યારે બરાબર છે કે તમે છોડવા આખા ઉપાડ્યા તો આખા છોડનું વજન લઈ શકો, પણ છોડની અરે 10 કિલોની 20 કિલો માટી હોય તો માટી તો ન જ આવે એમાં. જેમ કે બાકી તમે જુઓ તો આપણે ગાંજો છે તો એના ફૂલમાંથી જ બન્યા, પણ જ્યારે ખેતરમાં વાવ્યા હોય ત્યારે ફૂલે આવશે, એના પાંદડા આવશે અને એની દાંડલી આવશે અને એના મૂળિયા કાઉન્ટ થશે. તો મૂળિયામાં એક છોડની અંદર 500 ગ્રામ સપોઝ કે માટી ભેગી કાઢે તો એ તો ક્લિયર કરવી પડે. એમાં એવું ન કહી શકે કે માટીનો વજન તો ભેગો જ ગણો.
સર હું એવું નથી કહેતો આનું વજન કન્સિડર કરો, મારું કેવું છે, sir,
વજન કન્સિડર કરવા માટે ના વજન કન્સિડર એટલા માટે રિલેવન્ટ થાય કે સેક્શન 37 બાદ દરેક એનડીપીએસ કેસ માટે નથી.
આ એટલા જ
એ
માટે
કોમર્શિયલ ક્વોન્ટિટી માટે જ છે.
હા સર એટલે જ મેં સર આપ સરને સેક્શન વાંચી દીધું તો માત્ર સેક્શન પ્લસ કોમર્શિયલ એટલે ભૂલ ગણવાનું છે. એટલા માટે સર 37 આપ સરને ધ્યાન લાવવાનું એટલા માટે આ એટલે ભૂલ ગણવાનું છે અને સેક્શન આ આવે
એ જે હોલ ગણાય પણ તમે જે રીતે ગણવા માંગો છો એવી રીતે કોર્ટ માને કે ન માગે એ ડિબેટ તમે બતાવો કે આવી રીતે એઝ અ હોલ જ ગણાય.
સર આપને હિરાસની જજમેન્ટ સર આપને બતાવી છે.
જોઈએ આપણે
હા સર
એ આની સાથે તમે માટીની સાથે મિક્સ કરો તમે ફ્લોર સાફ કરો ને બધું મટીરિયલ આવે એ ન કહી શકાય.
ના એવું નથી કે તો માણસ જે સબસ્ટન્સ વાળું છે એની સાથે પાવડર છે એ બધું જ છે સર.
હા તમે
પાવડર સાથે એ બધું છે સર. મારો કેસ જ એવો છે.
તમે હું કહું છું તમે 50 કિલો વાળીને ભેગું કર્યું છે.
જી સર.
એ 50 કિલોમાંથી 7 કિલો મળ્યું છે
હા સર.
તો જુદી વાત છે.
સર એવું નથી.
પણ તમે માટી ને કચરો ને બધું જ કરીને તમે 50 કિલો ગણો
હિરાસની જજમેન્ટ આપતા તો રિપોર્ટ કરતો આપતો
કરી આપો.
જી સર.
એનીવે મને બતાવજો જજમેન્ટ તમે
સર મારી પાસે છે હું લઈને આવ્યો. મારી પાસે એક જ કોપી છે ખબર નથી ડોક્યુમેન્ટેશન આવશે તો પણ મારી પાસે મેં કોનું જજમેન્ટ હતું એના રિપોર્ટ કર્યું થર્ડ બેન્ચ કે ડિવિઝન બેન્ચ થર્ડ બેન્ચ ફૂલ બેન્ચ વાળી રિપોર્ટ
This judgment, what I don't think how you want to. It is specifically even the earlier judgment. This judgment is very specifically state after discussing all this. Okay, one drug is mixed with neutral, one or more neutral. In that cases, you are right. Okay, as a whole quantity is to be taken into consideration. But now in your case, how one can believe that dust particles should also be considered as a mixture because dust particles are no neutral substance. And neither the cocaine or water XYZ NDPS drugs cannot be taken along with. No one would prefer. Now, why these neutral substances that has also been dealt with? Okay, some are taken to be along with other drugs to get a big punch or for XYZ reasons. And that is also another form of a mixture, which makes this drug more, we can say more, you can go in your fantasy, whatever words you use. Along with mud or dust particle, that I doubt.
અને એટલા માટે જ આપણે આ જજમેન્ટને વાત કરું છું એટલા માટે સર કે ડિસ્કલ સબસ્ટન્સ સાથે પણ હવે સર આ કન્ફર્મ પાવડર સાથે આવેલ હેરોઇન ને જ્યારે વાળીને સાફ કરીને લેવામાં આવે છે ત્યારે એની સાથે જે પાવડરની સાથે ઘણું બધું આવ્યું છે એને જુદું પાડવું ના એફએસએલ માટે ના એનઆઈએ ડિપાર્ટમેન્ટ માટે છે નહીં સર અને એટલા માટે હું આપને એવું સબમિશન કરું છું કે 10 પાર્ટિકલ હોય શકે સવાલ જ નથી પણ એની સાથે સર પાવડર અને જે ટેલ્કમ પાવડર સાથે હેરોઇન આવ્યું છે સર એને બી જુદું પાડી શકાય એવું નથી કેમ કે હેરોઇનને એક પ્રોસેસથી જુદું પાડ્યું સીધે સીધું જુદું નથી પડ્યું
પ્રોસેસથી તો જુદું પડ્યું જ છે, એ લોકો જ પાડતા હતા.
હા સર
તમારા કેસ મુજબ
હા સર
જથ્થો જે આવે છે એમાંથી એ લોકો જ પ્રોસેસ કરીને ડ્રગ્સ બહાર કરતા હતા. ધેટ મીન્સ કે પેલો ન્યુટ્રલ સબસ્ટન્સ હતો જ નહીં, પાવડર, ટેલ્કમ પાવડર.
જી સર
ટેલ્કમ પાવડર એ ન્યુટ્રલ સબસ્ટન્સ હતો કન્ઝ્યુમ કરવા માટે.
જી સર
પછી એ જે એક્સટ્રેક્ટ કરીને માર્કેટમાં મૂકતા હતા, પછી નંબર ઓફ વેઝ છે મિક્સ કરે બીજાની સાથે. ઇન ધેટ કેસ ઇટ કેન બી અન્ડરસ્ટેન્ડ કે આ રીતે હોલ ક્વોન્ટિટી નું વેઇટ લેવાનું થાય. પણ અહીંયા તમે કલેક્ટ કરો છો ફ્લોર ઉપરથી કરો છો તમારા જ કેસ મુજબ, તો પછી એ કઈ રીતે થઈ શકે?
આ નેક્સ્ટ
અને આ ડિસિઝન નહીં, અગાઉનું ડિસિઝન બી વેરી સ્પેસિફિક છે. એ કેસમાં સુપ્રીમ કોર્ટે આઈ થિંક એક્વિટ કરેલા એવા ગ્રાઉન્ડ ઉપર કે આને તમે કોમર્શિયલ ક્વોન્ટિટી ન ગણી શકો, એકચ્યુઅલ જે કન્ટેન્ટ્સ છે એનું જ વેઇટ કરવાનું. એકચ્યુઅલ વેઇટ કરીને એમને કીધું કે આ સ્મોલ ક્વોન્ટિટી ન જ પડે છે, આને મેજરમાં ન ગણી, કોમર્શિયલ ક્વોન્ટિટીમાં નહીં ગણી શકાય. એ જજમેન્ટ આવ્યું. It was debated very from the government side, and therefore subsequent notification was issued by the central government to dilute that effect of that judgment.
સર એ જ કહું છું કે
અને
ઈ માઇક્રોગ્રાફના જજમેન્ટના સંદર્ભમાં એમ્બિગ્યુટી ક્રિએટ થઈ સર અને
હા, એમ્બિગ્યુટી ક્રિએટ થઈ હતી કારણ કે એ કોર્ટે એવું ફાઇન્ડિંગ આપ્યું હતું કે 1% નાખ્યું છે, મિક્સ કર્યું છે, એટલે પણ 1% જ કાઉન્ટ કરવાનું. એમાં ઇશ્યુ એ હતો કે 1% એડ કરીને 100% એક ડ્રગ્સ બને છે, જે ડ્રગ કન્ઝ્યુમ થાય છે. કારણ કે 1% લેવાની કોઈની તાકાત ન પણ હોય, એટલે ન જ હોય, ધેરફોર એ બીજાની સાથે મિક્સ કરવામાં આવે છે અને પછી યુઝ કરવામાં આવે છે. એટલે એઝ એ ક્વોન્ટિટી જે હોલ પકડાનું છે એ રિઝલ્ટન્ટ ડ્રગ જ છે જે કન્ઝ્યુમેબલ છે. એટલે ઇન ધેટ કેસ આખી ક્વોન્ટિટી કરી શકાય. એટલે સેન્ટ્રલ ગવર્મેન્ટ નોટિફિકેશન આપ્યું છે અને સબસિક્વન્ટ ડિસિઝન આ જ રીતના આવ્યા કે આખી ક્વોન્ટિટી કાઉન્ટ કરવાની છે, મિક્સચર કર્યું છે એની સાથે. તમારા કેસમાં તો કેસ સ્પેસિફિક છે કે આ ફ્લોર ઉપરથી તમે કલેક્ટ કર્યું છે.
પણ સર આપ જે કીધું ને આ ઇશ્યુ રેસ્ટ ઓફ તમામ ડિવિઝન બેન્ચના જજમેન્ટને લઈને એવું ઇશ્યુ થયો કે ઈ માઇક્રો જજમેન્ટ સાથે રિલેટેડ જજમેન્ટ પણ એવા હતા કે બે સાયમલ્ટેનિયસ જજ હતા. એટલે હવે ઈ માઇક્રો જજમેન્ટને માનવું કે ન માનવું એટલા માટે ઈ માઇક્રો જજમેન્ટને લઈને સુપ્રીમ કોર્ટમાં રિફર કરવામાં આવ્યું.
રિફર કરવામાં આવ્યું ન્યુટ્રલ સબસ્ટન્સની સાથે.
હા સર,
ન્યુટ્રલ સબસ્ટન્સની સાથે.
જી સર, હા સર, પણ એટ અ હોલ કાઉન્ટ કર્યું છે, સબસ્ટન્સ પણ એટ અ હોલ
એટલે હોલ કાઉન્ટ કર્યું છે, પણ એટલે હોલ સાથે કે ભાઈ મિક્સચરની સાથે.
એ વખતે આની સબ્જેક્ટ મેટર આ હતી, ઈ માઇક્રોના જજમેન્ટની અંદર સબ્જેક્ટ મેટર આ હતી.
Anyway, we will see. Yes.
સર એટલા માટે આપને મારી વિનંતી એટલા માટે મેં કરી છે તો ફાર હિરાસિંગ જજમેન્ટ એટ અ હોલ કાઉન્ટ કરવાનું કહું છું આપને એટલા માટે હિરાસિંગ જજમેન્ટ હતા તદુપરાંત સર આ કેસમાં જે ફેક્ટ્સ ને લઈને હું વધારે ડિસ્કશન નથી પણ સો ફાર કી વિટનેસ તદુપરાંત કી વિટનેસના 164 સ્ટેટમેન્ટ ડીઆરઆઈ સ્ટેટમેન્ટ જે હું આપને ઓલરેડી હરપ્રીત સિંહનું જ્યારે બે એપ્લિકેશન ડિસાઇડ કરી ત્યારે તમામ પોઈન્ટ વ્યૂ ડિસાઇડ કર્યા બાદ there were prima facie case ડિસાઇડ કર્યો હતો એ તમામ વિટનેસના સ્ટેટમેન્ટ અગેન આ કેસમાં પણ આપને રિક્વેસ્ટ કરું છું એ છે સર એક x3 છે સર આપને આપ્યું છે પછી x1 તદુપરાંત ડોક્યુમેન્ટ છે x1 નો 115 ડોક્યુમેન્ટ છે
What you want to say, except what is stated in your affidavit? What
Sir.
other points you want to point out?
સર પ્રાઇમા ફેસી આ કેસમાં આ આરોપી એપ્લિકન્ટ નું ઇન્વોલ્વમેન્ટ વિથ A24 ઇન અ કોન્શિયસ માઇન્ડ
Yes.
છે એવું આ સ્ટેટમેન્ટ ઓફ ધી કી વિટનેસીસ એન્ડ ડોક્યુમેન્ટ થી આ પ્રૂવ થાય છે સર આ જે આપ હરપ્રીત સિંહની મેલમાં ડિસાઇડ કર્યા એ સ્ટેટમેન્ટ એ ડોક્યુમેન્ટ એ કી વિટનેસ
Okay. એનાથી
Yes, sir.
કશું
એટલે સર પ્રાઇમા ફેસી એ જ બેલે અને આપ સાહેબનું જે જજમેન્ટ છે એની અંદર પણ ઉલ્લેખ છે કે આપ સાહેબે આ તમામ સ્ટેટમેન્ટ જોયા બાદ પ્રાઇમા ફેસી કેસ બનાવ્યો એટલે હું આપ સાહેબને એ જે નેગેટિવ પેરેડી આપ સાહેબને માટે રિક્વેસ્ટ કરું કે એ ક્લેમ કરી રહ્યો છું કે હરપ્રીત સિંહનું જજમેન્ટ છે જે આપે ઓર્ડર રેડ કર્યો છે અને એના બે નામ રજૂ કર્યા છે એ જ પેરેડી હું આપ સાહેબને ક્લેમ કરવા માટે કહી રહ્યો છું કે સેમ ફેક્ટ ઓફ ધી એવિડન્સ સેમ ફેક્ટ ઓફ ધી એવિડન્સ
Parity. Parity તો accused claim કરી શકે.
સર એક્યુઝમાં પ્રોસિક્યુશન પણ ક્લેમ કરી શકે છે ધેર ઇઝ સુપ્રીમ કોર્ટ જજમેન્ટ ઇવન સર નેગેટિવ પેરિટી ક્લેમ કરી શકે જી સર હું એટલા માટે આપને વિથ કોન્શિયસ માઇન્ડ આપને કહ્યું કે
Yes.
પેરિટી માત્ર એક્યુઝ કરી શકે એવું નથી સર એવા સુપ્રીમ કોર્ટ જ છે
કયું છે?
સર હું આપને આપીશ કે પેરિટી બહુ જ સાઇડ ક્લેમ કરાય નેગેટિવ એન્ડ પોઝિટિવ પ્રોસિક્યુશન એન્ડ ડિફેન્સ પેરિટીનો માત્ર રાઈટ એઝ પર ધ લો માત્ર એક્યુઝ કરશે એવું નથી સેમ છે સર બંને રાઈટ
Yes. ચાલો બીજું.
અને એટલા માટે તો હું નેગેટિવ પેરિટી આપને ક્લેમ કરવા માટે આપને
તમારા માટે નેગેટિવ કઈ રીતે? તમારા માટે તો તમારા માટે
નહીં પણ સર મારી માટે એવું છે કે સર પ્રોસિક્યુશન માટે એવું થયું કે સર આ નેગેટિવ પેરિટી ક્લેમ કરે છે પણ સર બંને માટે સર મારી માટે તો પોઝિટિવ પેરિટી છે મારી માટે
જેવી રીતે એ છૂટેલા આરોપીની સાથે પેરિટી ક્લેમ કરે એવું તમે નથી છૂટેલા આરોપી સાથે ક્લેમ
સર એટલા માટે તો જે નથી ચૂકેલા આરોપી પેરિટી ક્લેમ કરે
યસ. બીજું કઈ?
બીજું સર એમને એવું કીધું છે કે મોનેટરી ગેઇન નથી
હમ.
સર તો મારી એફિડેવિટમાં મેં ક્લિયર કટ બતાવ્યું છે કે એમને મોનેટરી ગેઇન જે અધર ધેન કન્સાઇનમેન્ટ આપ્યા છે એનાથી ક્લેમ કર્યું છે જે મારી એફિડેવિટમાં મેં સર ઓલ ડિટેલ્સ મેં આપને જણાવ્યું છે પેરેગ્રાફ કે કઈ કંપનીએ કેટલા પૈસા મેળવ્યા છે સર એ છે પેરેગ્રાફ સર પેજ નંબર 33 એની અંદર 46 મોર એવિડન્સ એટલે જે આ કન્સાઇનમેન્ટ પછી જે બાકીના કન્સાઇનમેન્ટ એ વિધાઉટ રેમિટન્સ મેળવ્યા છે એમાં મેજેન્ટ ઇન્ડિયા દ્વારા સર મેં લખ્યું છે પરફ્યુમ મેળવવામાં આવેલું છે ક્વોન્ટિટી 1 જે
કે સેમ
15%
એમનું આર્ગ્યુમેન્ટ એવી છે
જી સર
જે હરપ્રીત સિંહ કરતા જુદી એટલા માટે થાય
જી સર
કે ઓપરેટિંગ એમની આર્ગ્યુમેન્ટ એવી છે કે હરપ્રીત સિંહ બધું મોનિટરિંગ કરતો હતો, ટ્રાન્ઝેક્શન એને કર્યું છે, ડીલ એને કર્યું છે, હું તો ખાલી મોહરો હતો. એટલે હરપ્રીત સિંહની કેસમાં જે આર્ગ્યુમેન્ટ તમારી હતી કે એને આ ફોર્મમાં પૈસા લીધા છે, પરફ્યુમ છે ને કોસ્મેટિક છે ને ડ્રાય ફ્રૂટ ડેટ્સ છે ને એવી રીતે.
સર એટલા માટે
પણ પ્રિન્સ શર્માને શું મળ્યું છે?
સર એટલા માટે જો કી વિટનેસ સ્ટેટમેન્ટમાં એવું આવ્યું છે કે હરપ્રીત સિંહ આ આરોપી 825 ને પર્સન્ટેજ વાઇઝ આપવાનો છે સર એના સ્ટેટમેન્ટમાં છે key weakness.
કયા સ્ટેટમેન્ટમાં છે?
સર હું આપ સાહેબને સર બતાવી દઈશ.
અને કેટલી અમાઉન્ટ મળી છે એને?
સર પર્સન્ટેજ છે સર.
પર્સન્ટેજ શેના પર્સન્ટેજ?
જે આ જે કન્સાઇનમેન્ટ આવે ને ત્યાર પછી વિધાઉટ એની રેમિટન્સ પેમેન્ટ વગરના કન્સાઇનમેન્ટ
કન્સાઇનમેન્ટ આવી કન્સાઇનમેન્ટની એક વેલ્યુ તો હશે ને?
હા સર એની વેલ્યુ બી છે. ટોટલ 1.65 કરોડ હરપ્રીત સિંઘે આ રીતે ટ્રાન્ઝેક્શન કરીને
એટલે 1.65 કરોડ મળ્યા.
હા સર.
એમાંથી કેટલા પર્સન્ટેજ આને મળ્યા અને કઈ રીતે મળ્યા છે? આને તો ડેટ્સ આવીને પરફ્યુમ આવ્યું વેચ્યું કર્યું ને એ રીતે મળી ગયા.
હા સર.
પણ હવે તમારો પણ કેસ એવો છે કે આ ડ્રાઈવર હતો એનો,
હા સર.
એનો એમ્પ્લોયી છે
એટલું
અને એના નામની કંપની ખોલી છે.
હા સર.
તમારો પણ એ જ કેસ છે સેમ જે મેં એને કીધું કે તમારી આર્ગ્યુમેન્ટ પહેલામાં એવી હતી હરપ્રીત સિંહમાં કે હરપ્રીત સિંહ એ કાંઈ નથી કર્યું, જે થયું છે એજન્ટમાં થયું છે અને પ્રિન્સ શર્મા મારે કાંઈ નથી જોવા દેવા. હવે ફેક્ટ એવી રહી બંને માટે સેમ રહી, તમારા માટે ને એના માટે. તો આ પણ મોહરો છે એવું કેમ ના માનવું?
સર એટલા માટે નથી સર આનું સર આખી બિઝનેસ સ્ટેટમેન્ટમાં એવું ક્લિયર કટ ખબર છે કે મેડ ઇન ઇન્ડિયા જે કન્સાઇનમેન્ટ આવ્યું છે હેરોઈન છે એવું આ બંને જાણે છે. A24 અને 25 માય કેસ ઇઝ ક્લિયર કટ અને એવું નથી કે
એટલે કયા વિટનેસીસ માંથી આ જાણતો તો એ ખબર છે
સર
અને બીજું કે એને કેટલા પર્સન્ટેજ મળ્યા હતા એ કોના સ્ટેટમેન્ટ?
સર એવું પર્સન્ટેજ નથી, એના પર્સન્ટેજ આમાં ફિક્સ થયા છે કે જે કન્સાઇનમેન્ટ આપશે એના પર્સન્ટેજ હું આપીશ એવું કી વિટનેસ સર સ્ટેટમેન્ટ હું આપને બતાવીશ.
આ પર્સન્ટેજ તો કેટલા છે જોવો વાંચો.
હું સર કેટલા ફિક્સ નથી આમાંથી કે એ મળશે પર્સન્ટેજ એવું વાતચીત થઈ છે એવું કી વિટનેસ છે.
વાતચીત થઈ છે તમે વેરીફાઈ કર્યું?
હા સર.
તો પછી તો રિવીલ થવું જોઈએ ને કે કેટલા પર્સન્ટેજ મળ્યા છે.
પર્સન્ટેજ
અથવા એને
વાત મળી સર સ્ટેટમેન્ટમાં એવું આવ્યું છે
ફિક્સ
કે
કરવાની
પર્સન્ટેજ મળશે. આવું ફિક્સ સ્ટેટમેન્ટમાં એવું નથી કે આટલા પર્સન્ટેજ મળશે.
ઓકે
એવું છે.
તો હવે કઈ નહીં, હવે એવું કહો કે આને હરપ્રીત સિંઘે કેટલા પૈસા આપ્યા છે?
એ સર હું વેરીફાઈ કરેલું છે.
કારણ કે જો એને પૈસા ન મળે તમારો કેસ પર્સન્ટેજ વાઇઝ નો હોય.
હા સર. સર હું આપને મારી કોપી આપી છે એની અંદર મેં માર્ક કરી છે.
તો ભાઈ
એમાં સર મેં માર્ક કરી છે.
મને ઘરે આપી દેજો મારી પાસે એમ કહું છું કે તમે જેની પાસે મારી પાસે નહીં કદાચ તમે સ્કૂલની પાસે કરી છે આજે ઘરે મુકાઈ દો મને ખોટું કહી લઈને રાખી દે છે. હા ના એક નંબરમાં પેલો આપી ગયા રિપ્લાય લો જવાબ આપવાનો તો ડીએન સોલંકી. ફંક્શન કોડના કોણથી રિપોર્ટ નંબર રિમાર્ક્સ આવતી ચાલો. કોઈ આવે ચાલો તમારા માટે
સર,
આટલું જ બાકી.
સર એ પોઈન્ટ આપણે વાત કરી દીધી. મેં વાંચી દીધું સર તો આપણે ચેક કરી આપણે and that's row 4 and the quantity shown in column 5 and column 6 of the table, that is small quantity and commercial quantity relating to respective drugs shown in column 2 shall apply to the entire mixture or any solution or any one of both alcoholic drug or psychotropic substance from that particular drug in dosage form or isomers, esters, ethers and salts of these drugs, including salts or esters, ethers and isomers. Only these are the things which can be added to a drug as a neutral substance for the purpose of determining whether it is a small quantity or commercial quantity. And this note 4 in the notification was under challenge before the Honorable Supreme Court in Virasi. And this note 4 has been interpreted by Honorable Supreme Court saying that only a deliberate mixture, like a street level heroin, which is called as brown sugar, contains various mixtures. And like the Honorable Court rightly said, the purpose of mixing is various. One is that it should give a sweet effect. Second is that it should give a higher kick. Third is that it should give a longer kick. The kick should remain longer. Those are the purposes. So every neutral substance which is added to the pure drug has purpose. It is like adding a battery cell into a local battery liquor. There is a purpose for that. So without a purpose, if it is purely based on sweetening, I am honorable court for inviting attention of all the people involved in this matter at that point. But if it is a sweetening, then and dust also comes with it, sand also comes with it, stones also comes with it. The entire thing cannot be considered as a mixture. And if that is the case, what is the actual quantity of the product which has come? The heroin which has been imported in a neutral, along these two neutral substances is not determined in this case. There is no chemical analysis report which is indicating the determination of the drug content, even in terms of Virasi's case. That is the humble submission. Hence, the power of medicine will not apply.
And even otherwise, because of the non-applicability of 22C, 43B5 of the GL will be problem. That is number C.
ક્યારે
सर आपको क्या काल में आप काल एक
કાલ?
सर सिविल सेक्शन पर आप अपने बनने में
પરમ દિવસે 24 તારીખ.
सॉरी